Hi, I'm Daniel White from Mills Oakley Lawyers in Perth, and I want to speak to you briefly today about enterprise bargaining and how important it is to get the process right in order to get a valid enterprise agreement approved by the Fair Work Commission. You no doubt would have seen a lot in the media recently around the importance of the Notice of Employee Representational Rights and how critical it is to make sure that that is absolutely perfect in terms of the schedule that's provided in the Fair Work regulations. On 3 April 2017, there's going to be a new Notice of Employee Representational Rights. It's important to make sure that any new enterprise agreements you make after that date utilise the new notice. When drafting the enterprise agreement, it's critical to get clauses absolutely perfect to ensure that you are not putting cost into your business that isn't otherwise accounted for. Important aspects around the accrual of annual leave, also the ordinary hours of work, and also the payment of superannuation. The enterprise bargaining process can be done within a 23-day period, and it obviously can go for a lot longer as well, sometimes up to 2 years, depending on whether or not there are some unions involved in the bargaining process. But throughout it, it's important to have direct communication with your employees, explaining how important the enterprise agreement is for your organisation and where you want to take it. And having employee buy-in is, from my experience, the most important aspect of getting an enterprise agreement approved through the employees and then the Fair Work Commission. In terms of the approval process itself, there are often occasions when unions may object to the approval of the agreement, and we're seeing that a lot happen with non-union agreements in the Commission. That includes agreements that have been approved and then subsequently are appealed to the full bench. It's important to make sure that if you have the whole process properly done in terms of compliance with the Act and ensuring that your agreement passes the boot, there are often very good grounds in order to defend any type of appeal by a union, and we're seeing that particularly, as I said, in the construction industry. Once the appeal has been heard, the agreement, if it's not overturned, will remain in place, and it's critically important for some companies, for those who are tendering on major projects, to actually keep that agreement valid when they have been tendering on the wage rates that are included in those agreements. I'd be happy to answer any questions that you might have around enterprise agreements. It's something that I do day in, day out, involved in lots of different industries, and please drop me an email if you'd like to know anything more.